My name is Dawn Drozd, and on behalf of the League of Women Voters of Grosse Pointe, Harper Woods, and Detroit, I'd like to welcome you to tonight's program, From Darkness to Light, How Michigan's Sunshine Laws Impact Your Civil Liberties. Before we get started, I want to thank the War Memorial and Leah Chelaby for sharing this beautiful venue with us, and give a shout out to the Committee of Women who put in countless hours to bring this program to the community. I'd also like to introduce the president of the Grosse Pointe League, Lynn Pierce. Lynn, will you wave? And the two co-presidents from the Detroit League who we partnered with this, Sarah Wirtz and Deb Bunkley. Many of you know that the League of Women Voters is a nonprofit, nonpartisan organization whose goal is to empower voters and defend democracy. Tonight's topic is certainly relevant to that. So without further ado, I'd like to introduce you to your moderator for the evening, Joan Richardson. Joan?
Getting my exercise, just stepping up on the stage there. So just one small housekeeping note before we started. We did ask everyone who registered to attend to submit their questions in advance, and we got dozens of questions, which we'll be holding until we do the Q&A at the end. However, if you hear something during the presentation that prompts another question for you, we have note cards that will be circulating. We will not have a microphone for you to ask questions during this event. So sometimes these days I get the impression that we think that transparency in government is something that we created in the 21st century. And I want to set the record straight on that. There's nothing new about a concern about transparency in government. The Federal Freedom of Information Act was passed in 1966, 57 years ago. Some of us have lived our entire careers being familiar with FOIA and Open Meetings Act. Michigan followed with its own version of FOIA 10 years after that, and also with the Michigan Open Meetings Act. So there's nothing new here about a concern about ensuring that we have access to public records or ensuring that public bodies do, in fact, meet in public. I also want to say that there's nothing partisan about this. Every person on this panel, I'm quite confident, could tell you stories about situations in which people on both sides of the political aisle have refused to provide access to records and attempted to close meetings. Before I introduce our speakers, let me emphasize one other point here that I think is very important. We are talking here about the people's business. We are not sticking our noses into the inner machinations of private companies. We have different laws and regulations that govern corporations. What we're discussing here tonight are our meetings, our records. Public officials have been given the privilege of representing us, making decisions on our behalf. When we ask to see a document that they create, it's because that's our document. And when we ask to attend a meeting, that's because it's our meeting, it's not their meeting. So with that, let me introduce a panel of really exceptional speakers. We're going to begin tonight with, I'm going to introduce them in the order in which they'll be speaking. We're going to begin with Christine McDonald, who has been a newspaper reporter for 25 years in Michigan, including writing for the Lansing State Journal, the Jackson Citizen Patriot, the Detroit News, and my personal favorite, the Detroit Free Press. She currently coaches the Free Press Investigations team as an assistant editor and reporter. Her award-winning work in Detroit has brought significant change. She's helped save library branches, prompted crackdowns on property buyers who abused tax foreclosure auctions, and forced changes in Detroit's property tax system. Her most recent work has brought attention to deplorable living conditions in the Wayne County Juvenile Jail. She'll be followed by Ralph Simpson. Ralph is a longtime attorney, activist in Detroit. He specializes in the Freedom of Information Act and Open Meetings Act, counseling, and litigation. He's a graduate of the University of Michigan Law School. He's represented nonprofits, local and national journalists, community groups, elected officials, and many others in FOIA and OMA cases. He's also served in many volunteer positions, most notably, I think, as president of the ACLU of Michigan. After he speaks, we'll be joined by Gary Sachatal, who's a partner with the law firm of Keller Thoma. Gary is a graduate of Wayne State University Law School, and she's concentrated her practice in public sector law, labor law, employment, and civil rights law. Of particular interest to us tonight is her work in school law, in which she's advised and defended school districts throughout the state. Her law firm does not currently represent the Grosse Pointe Public Schools, but they do represent, I believe it's the Grosse Pointe Woods City Government. And she'll be focusing her comments tonight on the Open Meetings Act. But we're going to begin with Christine. Thank you.
Thank you. It's great to be here and to see so many of you interested in this topic. I think it's really important, and I appreciate you being here and to talk about this. FOIA is a crucial tool for myself and my colleagues in what we do, and if we didn't have that, unfortunately, we wouldn't be able to do the depth of the stories likely that we're able to do. I think, just echoing some of her comments, that yeah, the vast majority of government, the business of government, should be public, and it shouldn't take a FOIA. You know, we should be able to get some access to basic documents in a reasonable time period. But unfortunately, because what I've found as a reporter is that public officials are so across the board on their philosophy on transparency and access to public documents. So often we are forced to use FOIA as reporters. You know, you as a citizen may have better luck, you know, going and getting some data, you know, some information from your local mayor, township, whatever, but I'm constantly, you know, blocked and told to FOIA even the most basic of police reports, which should be clearly public, some of the other just clearly assessment data was a recent, hill that I had to climb with a county, you know, to get this information. And Wayne County, let's say, I'd like to highlight some people who are doing it well. Wayne County puts their data online. It's free, and so you're able to get a lot of that. Depending on the philosophy of the public official, which it shouldn't work like that, in my opinion. So I think I wanted to ask, you know, I'm tasked with some of the basics of FOIA. I want to give you, you know, run through some of the basics and pitfalls that I've, you know, encountered. I don't know, how many of you have filed a FOIA request before? Yeah, so a good amount, yeah. And how many were denied? Yeah, it's pretty common. I think, so some basics, you know, by state law, entities, you know, public entities, the vast majority that do have to respond to FOIA. Keep in mind, there are some quirks in the system where some entities are not covered by FOIA, and you should do the research and find that out. Courts are a big one that do not have to respond to FOIA, which is a difficult hill for me in my job because of what I've been covering recently in juvenile courts. So I'm unable to use FOIA to get some of that bulk data. I can look up, a lot of that data is public court data, but bulk data and FOIAing them, it's more difficult. So find out, you know, is the entity that you're FOIAing, do they have to respond? So typically it's 5 days, and they'll send you, after you make that request, they must send you an acknowledgement that they've received your FOIA. Typically, whenever I do that, that response is we're going to take a 10-day extension to, you know, get this information, no matter what it is, even if the simplest, you know, your budget, let's say, you know that is accessible and that probably doesn't need another 10 days to search. You know, we do get that all the time. So that is allowable under the law. And another difficulty is that really there's no specific deadline from these entities to produce the data. I'm currently dealing with Michigan Department of Health and Human Services and FOIAing a lot of reports, investigations related to the juvenile detention center in Wayne County. And I'll put in a FOIA, they'll respond, I'll pay, and they said, well, we hope to get back to you in 45 days with the information. And that's what's frustrating as a reporter, because it's such an urgent, dire situation, and for me to have to wait, 2 months, 3 months to be able to report on the incidents that are happening in that facility and kids that are at risk, it's maddening as a reporter, but a priority at the state level is not put to having enough FOIA officers. I mean, I guess I'm being a little kind, because they don't have to redact a lot of what I'm requesting, because the names of kids are not in these files, typically anyway. But I just want to warn you that there is really no requirement, and Ralph can help me here if I'm wrong, but that they respond to you in a certain amount of time. You can probably appeal and try to force a quicker response, but I'm not aware of a deadline. Or, even national reporters, when I see a lot of people tweet about frustrations with FOIA at the federal level, there's horror stories of reporters getting FOIAs back 10 years after, from federal agencies, 10 years after they file these requests, which is quite a commitment for these agencies to keep track of that FOIA for 10 years. And so you got to give them that, I guess. But there are many problems with the law. I think one of them, too, is that redactions, they're really, what I find in my career is, again, that philosophy of how deep they want to go with redactions can be very deep, and what they consider private information, it can really make your request worthless. And I've also seen horror stories where people will post online their FOIAs, and it's like page after page of blacked out redactions. So that's a challenge as well. One other thing to realize, these public entities in the law, they're not required to create a document for you. You're requesting something that already exists. They're not required to create something for you. So I think in my work, what I try to do is, and it might be a challenge as a citizen, but to have conversations with people in the know, so I know what does this document look like? What does the database look like that I'm requesting? What does the Excel file that I know exists? Tell me about it, so I can be really specific in my request, so it doesn't get rejected, or it doesn't. They tell me I'm not specific enough, or that's one thing to think about, and to try to. I think public officials hate and the fishing expeditions a lot of times that reporters have very broad FOIAs that we're trying to find some information, and that can be a challenge if we have a tip and we know something's there, but we don't have a specific. So a lot of times we'll put in broad FOIAs, and then you'll get back the $10,000, $15,000 FOIA cost. So I think the challenge is, for example, being specific, like if you're trying to get correspondence between two entities, let's say, I know I did from the flooding, a couple of years ago, between DTE and GWLS, the Great Lakes Water Authority, but I had to winnow it down to like a 2-week email period, because the cost would just be prohibitive for me to request everything. So those are some things to think about to being effective. I don't think it should work this way, but the reality is that we need, particularly, I need something from them to pursue these stories. So I try to do my best to work around the failings in the law, I guess, is how I would characterize it. So. Yeah, Ralph, do you want to?
Thanks for inviting me. Thanks for inviting me. I'm really happy to be here, and I hope make some of you at least feel better about the process of submitting FOIA. On the one hand, I fully understand the feeling of frustration. I've represented or counseled journalists, elected officials, and even organizations like the ACLU who've filed dozens of freedom of information requests, and sometimes they're granted. And when they weren't, generally, they just moved on and did a different variation. But I think there are some strategies, there are some approaches that you can use that I think can lead to more success, and certainly can lead to success in litigation or appeals if you eventually feel you have to go that route. Christine talked about a number of things about the basics, but let me reiterate a couple. Of course, in ways of having success with even the basics. One of the things I hear complaints about, you have to submit a written request to the public body. A number of people, I never have particular problems with the post office, but a lot of requests seem to get lost for some of the people who are submitting them. So that would be one of the most basic, whether it's by email or in writing, get a confirmation. It's frustrating enough without waiting a month and then finding out that they're going to say that they didn't receive it. Of course, there are sending it to the appropriate person. Again, they actually do have, public officials have a responsibility to pass it on if they somehow get something that isn't directed to them. And, you know, basically it's pretty clear that it's the head of the agency or someone that they designate that gets a FOIA request. The good news is that most public bodies, and I prepared some brief materials that have some of this information, and I wanted to focus more on strategies and problems than just on how to do it. Again, I'm going over some of the points about how to do it, but I think those you'll usually get in what, as Christine was suggesting, is the art, and the difficulty is doing things better and more successfully with less frustration. So the materials that I did prepare for the handout contain a number of different links, from guides to the FOIA law that has some answers to very specific questions, to letter generators. If you're more comfortable doing that, it can also be, those type of links can also be useful for getting the exact address so you're more confident about that. I like to submit an actual letter myself, and you can usually get the email address rather than using their God, what would you call it? Yeah, portal. I would write my letter out and not fill in the blanks. For one reason, it's hard to keep track of as you go along if you are going to appeal it. If you have it in a PDF form where it stays the same and you have as much control of it as the public body does, I think that's a lot more helpful if you are going to have to take some additional steps. The idea of sufficiently describe to locate the records, that is something that often is abused. If the law is very clear that you do not have to be precise. They're the ones who know the precise language and what documents they have, and you are not held to that standard. But there is still a benefit, and I will talk about strategies for having more success. Again, you don't have to be totally precise, but it's better if you do have more information in particular kinds of information. So when you look at the most common reasons that requests are denied, I think Well, as I said, one is the idea that they didn't receive it at all, and that's usually more of a delay tactic, I think, than actual denial. The other is very commonly that they don't understand what you're asking for. And sometimes there's actually some reality to that, and that's something I think a lot of people don't appreciate, and I've dealt with lawyers who don't fully appreciate it. There's no, as far as I know, no specific requirements for the person who answers FOIA requests. And it can vary quite a bit from a clerical person to administrative person to a communications person to an internal law firm to a law firm. There's a number, and sometimes it's surprising who hires the law firm and pays a lot of money to have FOIA requests answered, which can be good and bad at times. It's good. I think a lot of the law firms make money responding, so they have an incentive to respond, but then they might have a more sophisticated approach to denying at times. And sometimes it's good, sometimes it's bad, and I think that that's something that's true with a lot of situations. See, I would think if I was part of a government agency and the Free Press called on me, I'd think, wow, I'm going to get in trouble if I don't respond to them because they have so many resources. But on the other hand, they're more likely to hear more about it, and they're more likely to be embarrassed by it, and so it can cut both ways. And even with the ACLU, I look at it. I'm representing the ACLU. Well, yeah, I think God, they got access to a lot of lawyers. I'm going to respond to them first and more effectively. But that isn't always the case. Some of the things that you think might work in your favor actually can motivate them not to respond or to limit the response or to drag out the response. On the other hand, it certainly, I know from representing community groups, that sometimes they're routinely blown off. And I think way back in law school, I learned of what they called then the insurance strategy, where you put a clause in a contract that you know is illegal, but it benefits the company, but 99% of the people won't challenge it. So I guess other companies have been accused of variations of that. So that's a reality that sometimes there are motivations for doing things. On the other hand, though, and I brought this up before, I don't want people to approach FOIAs with a negative frame of reference. I think often people have a lot of success, and different government entities have a totally different cooperative approach, and just one, either they think it's a good thing and buy into the strategy, or else they just think it's a part of government. So I'm going to raise a few points, and again, I prepared some materials that I think have a lot of basic. So I was going to focus more on strategies. And after I made a few more points, I was going to hand it back to Christine and then come back to some of those strategies. So I always think that that people, when they approach FOIA with the idea that the law really is very much in your favor. The burdens are for them to prove that you're not entitled to it. The information is the presumption is supposed to be that the public has a right to information. In court, when the government body goes to court, they're supposed to be the one showing why they did what they did. Anyone can ask for it. You don't have to present a reason for why you're asking, or you don't have to provide an explanation of what you're going to do with the information. And if you ever do actually get into court, that's a huge plus, because a lot of times civil litigation, and it is litigation if you do get to court, it can drag out. But if you're suing someone because the automobile is defective, you have the burden of showing it was perspective, and they get to ask you a lot of questions. And that drags out and makes more expensive the whole process. With Freedom of Information Act, again, since there's very little they can question you about, it's one-sided, typically one-sided litigation. It doesn't mean it isn't still a burden on the person as far as time or the need for the information, but that does make it much more feasible to have relatively low-cost litigation if you, again, do get to that point. So before I turn it back to Christine, and come back to discussing some strategy, I think I worked in government, on the state and federal government for a lot of years, and worked in Washington, in Michigan, in Detroit for the state. And there are some tremendous people in government service. I mean, some of the best attorneys, the best people. There really is a variety. And I don't want anyone to approach things with the attitude that they're going to lose before they see some evidence to support that. But one of the things I like to have people to think about is what are the various reasons that things happen. One, as I mentioned, there's no requirement for training or knowledge or skill for being a FOIA coordinator. So sometimes people just honestly don't know, and a more difficult request, or don't have permission to release the information. Sometimes they've been told a particular thing, like the thing Christine mentioned about the list, which is one of the things I'll come back to, and if not, I'll have questions on it. I'm going to wrap up a little because I want Christine to be able to we're sharing time a little. Why are people denying it? Again, it could be lack of knowledge. It could be the insurance strategy. It could be lack of resources. They aren't always well-funded or well-supported. It could be political reasons, avoiding embarrassment. It could be improper policies that are set from above. And it can be, at times, hostility to the requester. So you have to think of things as you go into it in more difficult requests. And two of the things that I really like to know is who is the person who's going to be responding, and who is the person or the group or entity that is going to hear appeals if those are necessary. Yeah, proceed.
And that's what I want to talk about. There is this important step built in the law that you can't appeal a denial, and that you would get to that point before you would challenge in court, right? And I know I don't think I've ever had a court case with the Free Press or the News, so that doesn't. It's pretty rare I think, to take a FOIA case. At least in journalism, we don't like to pay our lawyers, to do that. Unfortunately, I wish, because I've had some really good ones. I think we could have won, but we just, But appealing, I've had some luck with, and you're typically they in their response, their denial. I know you said you had a denial, right? That they would have to say who you can appeal this to, this decision, and so consider that. Maybe you appeal and make an argument. What was their argument about? It depends on their argument about, did it exist? Are they saying it didn't exist at all, or that you, or it's not maybe they said it's a. They would have to create this document, or maybe the cost was prohibited, right? They'd say it's $10,000, and that's what I get a lot. And I've had some luck recently with Wayne County. There's a court in Wayne County system where if you FOIA any agency in Wayne County, you appeal not to that entity, you appeal to Wayne County Executive Warren Evans. So if I filed a FOIA with Eric Sabri, the treasurer, but I wanted to appeal, I wouldn't be appealing to Eric Sabri, and that's normally what you're appealing, to a school board of that entity that you filed a FOIA with. I'm appealing to Warren Evans, and so you get a little bit of, it's a different public official who might have a different philosophy about what I might listen to my argument, and I've actually gotten luck. I think it was with the sheriff's department. I FOIA'd for information on people on Tether and when they got on Tether, because we had done a piece on people waiting in jail. There were some people last year waiting in jail for 2 weeks without getting for a Tether, because there was such a backlog. So this was really important, data that was affecting people's lives dramatically, staying in that jail for longer when they didn't have to. So Warren Evans granted my FOIA, and I think it was a cost issue, but I may have been remembering incorrectly. But I know the appealing works, so you should consider that. And let's say you appealed. Why can't you go to that school board that you're appealing and explain your appeal at public comment? That could be a strategy. People should know their public officials are denying FOIAs and why they're denying them. And so if you're denied, I would, if I was a citizen, I would use that as an opportunity to let everybody know how they responded, and how the appeal that you filed. So trying to think of anything else. You can appeal redactions too. Let's say, they have to specify. A lot of times, I think that's a thing that FOIA officers kind of gloss over. They have to tell you why they're redacting and what information in general, what their argument, that it's personal information or proprietary or whatever the part of the law they're citing. And I've had some maddening redactions that, just a quick example is, about 10 years ago I did a story on Section 8 landlords. So these are folks getting federal money to rent to folks, low-income folks, and I wanted the list of Section 8 landlords, and they said, well, we don't want to give you that because it's it's private information. These folks are these addresses. Well, and they didn't want, that's private for those folks who are renting those homes, but they're basically contractors, these landlords, with the federal government. And actually, I found on MSHDA's website where they were listing all the addresses anyways, because you want people to know where they can go to rent Section 8 landlord, houses. And so I made that argument in the appeal. They did not grant my appeal, as my recollection, but what happened was they sent me a FOIA or Excel file with all the landlords, but it was they didn't give me the addresses, but the FOIA officer had just in Excel had noted them out, but they were actually there when you put your cursor over it. So I was actually able to do the story anyway. So, and we found, it was an impactful story, that a quarter of those landlords were not paying property taxes. So they were collecting federal government, rent assistance, and then their houses, they weren't paying Detroit property taxes, and they were, because of quirk in the system, were rebuying their own houses at the auction back in the day when the prices were so low. So we had guys who would profit, I want to say, like 10, 20, 30, 40,000 over this 5-year period. He wasn't paying any property taxes, and then just rebought his house of no penalty. So this is why that's so important that we get this data. And then the federal government instituted a rule after that story that we were going to check to see the status of property taxes. So, yeah, sorry.
I think we're going to move on to Gary right now. Thank you very much, but let's move on to Gary and start to hear about Open Meetings Act.
Hi, everyone. So my perspective is probably a little different than my colleagues here. Is this better? Okay. All right, so my perspective is probably a little bit different from my colleagues here because my job is to advise public entities and defend them in lawsuits involving the FOIA or the Open Meetings Act. But I was going to give you sort of a rundown of the Open Meetings Act. I think it's a law that is sometimes not clearly understood by the public in terms of what is required by the public entity and what is not required by the public entity. So I'm sure you all are aware that the purpose of the act is in the name. It's to govern open meetings of a public body, and the purpose of the act is to promote transparency in government operations. And the main sort of thrust of the statute is that all public meetings of a public body be held open upon notice to the public. And so there's a couple of components there that require further explanation to understand who it governs, in what circumstances does it govern, and what does that notice look like. So public body is pretty much what you would think it would be. It's school districts, it's cities, it's counties, it's subcommittees of those entities as well. So basically any sort of commission, committee, or the public body itself. So public body is pretty straightforward. What is a meeting? A meeting is where a quorum of the public body comes together to deliberate or to make a decision on a matter of public concern. So does everyone understand what a quorum is? I think that's pretty self-explanatory, but the number of people that constitute a quorum will depend upon the number of elected officials that sit on the public body. So for a group of 7, it's usually 4. A group of 11, it's usually 7. So you have to have a quorum before you can even start to think about whether or not that quorum is engaging in a meeting that would be a meeting under the statute. So let's say you have a quorum that's come together. That quorum then needs to be deliberating or deciding. So deliberating is just what it sounds like. They need to be discussing, debating, having some sort of back and forth discussion, or they need to be making some sort of decision. And usually when we're talking about a decision, we're talking about a vote of the public body. So there has to be a vote, or there has to be some sort of debate. And then the last component is that they have to be deliberating or voting on a matter of public concern. So anything that impacts the public body itself would be a matter of public concern. Now, there are circumstances where you could have a quorum together where they're discussing something, but it is not a meeting for purposes of the Open Meetings Act. Say a social gathering, say a chance meeting, workshops, for example, where they're being trained. But if there's any sort of possibility that what they're going to talk about will impact the public body, that is something that would be subject to the Open Meetings Act and subject to notice and being made public to the public to attend. We have clients, for example, that will do retreats. I don't know if any of you have experienced that with public bodies that you keep track of, but oftentimes, for example, school boards will go on retreats to learn about various topics that may affect governance of a school district. And I have always advised that those types of retreats should be made public. They should be held open, because the chances of there being discussion about matters impacting the public or the public body itself are very high. We're all human. It's only natural that you're going to start talking about what you're all there for, which is learning about how to govern the public body that you've been elected to represent. And so, things like retreats, things like workshops, I think they sort of blur the lines between whether or not this is really a matter of public concern or not. And our advice, my firm's advice has always been err on the side of treating it like a public meeting. What about emails and texts? So I get this question a lot from clients. Emails are can be considered a meeting if they meet all of the other requirements for a meeting. So if you have a quorum of public officials on an email or a text, if they're discussing something that impacts the business of the public body, then that email could be an open meeting, or could be a meeting for purposes of the Open Meetings Act. And that means that email should have been made public, where the public could participate in that email exchange. There should have been notice, so it should have been treated like a meeting. I had a case some years ago where we had 4 members of a public body that were engaging in email communications prior to meetings, talking about various issues that were going to be coming in front of that public body, and coming up with a strategy on how they were going to address them at the meeting, and then sometimes discussing how they were going to vote. And two of the other members of that public body got wind of what was happening. They FOIA'd the emails, got the emails, discovered that these four were engaging in these email communications, and they sued them under the Open Meetings Act. And that case went up to the Court of Appeals, and the Court of Appeals held that those emails were in fact meetings under the Open Meetings Act, and that by engaging in those discussions through email where the public was not able to participate, they violated the Open Meetings Act. So email communication is, and this is, a huge issue that I find with our clients, is that they don't always understand that, especially if they're new to public service, that they can't engage in discussions by email. Now, email being such a ubiquitous form of communication, it is hard to not use it as a means of communicating information to public officials. But oftentimes, if I, for example, will send an email to, say, a school board members, I will preface the email with, "This is for information only, do not respond, don't reply all. If you have a question, just reply to me." And most of the time, people are good about that. They all seem to, it's been many years now that email has been a tool that is being used by public officials. I think most people get it. Texting, on the other hand, is still something that people are grasping, still struggling to understand that text messages, if they meet all of these requirements, can also be considered a meeting under the Open Meetings Act. And that, incidentally, texting on your personal device makes your personal text messages subject to FOIA. This is a conversation I've had many times with clients, that you need to be careful about using your personal email and your personal cell phones to text, because it could also be a FOIA issue, and it could be an Open Meetings Act issue. So emails and texting are, areas that, public officials from time to time forget can constitute a meeting. I talked about the case where I had some members of a public body talking about how they were going to vote. Already? Okay. So canvassing is allowed. Canvassing is where one member of the public body informally polls other members of the public body to find out where the votes might be on a particular issue. So as long as they're not discussing, you can go to board member to board member, city council member to city council member, and say, "Hey, how are you planning on voting on this issue?" That does not violate the Open Meetings Act. Let me just quickly talk about closed session, because obviously the default is that meetings should be in the open, but there are specific exemptions that allow public bodies to go into closed. And again, an area I see our clients struggle with from time to time is limiting the conversation once they're in closed to the reason that they're in closed session. You can't discuss everything now that you're in closed session. You can't use closed session to go into closed session and then talk about something else. You can only talk about the thing you're in closed session on, and then once you're done with that discussion, you have to go back out. You can't make decisions in closed session. You can reach consensus, but you can't actually vote. All votes have to happen in open. So the big ones for closed session are personnel-related reasons. So if you're discussing discipline, performance evaluations, a complaint against an employee or a public official, then if the employee or the public official wants to go into closed session, then the public body can go into closed session. If they don't, if they want to have that personnel matter discussed in open, then it has to happen in open. Only in that situation can the employee decide whether or not it's going into closed session. The public body doesn't get to decide that. Collective bargaining, so if you're negotiating with a union and you want to talk about the strategies or the contract that you're finalizing, you can go into closed for that. Real estate transactions can be discussed in closed session. If you want to discuss strategy on pending litigation, you can go into closed session to discuss pending litigation when the public entity is a party to that pending litigation. And then the final reason is a written legal opinion of legal counsel. So if I write a legal opinion to advise my client, they can go into closed session to discuss my written legal opinion. Really quickly on notice. Notice is just notice of the meeting. A lot of people think that the Open Meetings Act requires the public body to post an agenda. It does not. There's no agenda requirement in the Open Meetings Act. However, almost every public entity that I work with does post an agenda because most of them follow Robert's rules or some sort of parliamentarian procedures which require an agenda to be posted. But the agenda itself, there is no requirement in the Open Meetings Act, and therefore the form of the agenda is really up to the public body, whether they have one and then what the agenda says. So I guess I'll cut it off there, and I'm happy to answer any questions.
Okay, great. Off to a good start here. As I said, we had a lot of questions, so I'm going to try to sort through them here. And Gory, let's keep you on the hot seat for just a minute. You didn't talk about penalties for violating the Open Meetings Act. Can you talk a bit about that?
Sure. So there's a couple ways to enforce Open Meetings Act violations. One is you could alert the Attorney General's office, and they could potentially bring an action, although that's usually not a very likely way of getting any sort of relief. The more common approach is that you could file a lawsuit yourself in circuit court, and you can file that lawsuit either against the public entity or you could file it against individual members, individual public officials. And the penalties are a little different. You can seek injunctive relief if it's against the public entity. So you could seek an injunction that would require them to stop violating the Open Meetings Act or to undo an action that happened as a result of a violation of the Open Meetings Act. Let's say they failed to properly notify the public of a meeting and then there was a vote taken at that meeting, then there could be an injunction saying that action or that vote is, invalid and is undone, whatever the action was. And then you can, if you're successful on that, you could recover your attorney's fees for having brought the lawsuit. There's civil penalties against public officials who violate the Open Meetings Act. So there's a fine, and you could get some sort of nominal damages against an individual. But keep in mind there are time limits, so you have to bring these actions fairly quickly after they happen. I think it's 6 months against individuals, against the individual public officials. Otherwise, the claim is barred. So that's kind of a rundown on them.
So what kind of evidence do you have to have that a meeting has been closed inappropriately?
Well, that's a good question. So there's always procedural sort of errors, right? So if the public body doesn't properly describe the reason why they've gone into closed session. So the public body, when they take the vote to go into closed session, should be giving sufficient information to make it clear, this is the reason, this is the exemption that we're applying, or we're going into closed session on. But typically, you're going to need some sort of documentary or testimonial evidence. And most of the cases where I have seen somebody challenging a closed session are not usually successful because who's going to tell you what went on in closed session? So, sometimes you might, have somebody like a third party that was in there for whatever reason, and maybe that's the source. The other thing is meeting minutes from closed session are very big because it's a closed session and what's being said there is confidential. And so you can't get closed session minutes through FOIA. You can compel their production in an Open Meetings Act lawsuit, but usually what you're going to get, if they're my client, is something really bare bones. So that's not going to tell you what was discussed. So, to answer your question, for a closed session violation, I would say good luck.
Okay. Can you talk a bit about what the Open Meetings Act does or does not say about regarding public comment at a public meeting? Whether they're required to have public comment. One of the issues that has arisen locally is the restrictions on public comment, allowing it, but establishing restrictions that many people have concerns about. So if you could just explore that a little bit.
Yeah, sure. So public comment is required under the Open Meetings Act, but public bodies are allowed to impose rules on how public comment happens. So, and usually that's in terms of time limits, but they have to be consistently enforced. If they're not consistently enforced, then you could have an Open Meetings Act violation, right? So if I like what you're saying and I give you 10 minutes, but I don't like what you're saying and I give you 1 minute, then that's not fair, that's inconsistent, that would violate the Open Meetings Act, in addition to maybe other constitutional claims you might have for being discriminated against on the basis of your First Amendment rights. They can require you, for example, to identify who you are. Again, it has to be consistently enforced, but they can require, as a condition of being allowed to speak during public comment, to tell us your name, where you live, that kind of information. They can't ask that if you're just attending and sitting in the audience. That's not allowed under the Open Meetings Act. If you're just there to watch, they can't ask you to identify who you are. Or I should say, they can ask, they can't compel. But if you're speaking during public comment, they can compel you to do that as a condition. They can't limit the amount of time allotted to public comment, but they can, like I said, impose time limits on the amount of time each speaker has to speak. But if there's 100 speakers that want to speak, then all 100 are supposed to be able to speak under the Open Meetings Act, and they can't cut you off after 50 because it's been 2 hours and we all want to go home. So
I'm going to just double check that point. So the public body can say that you can, the 3 of you are allowed to speak, but you can only speak for 2 minutes each.
yes,
But if there's 50 of you who want to speak at 2 minutes each, they have to allow all 50 people. They can't say we're only going to have 45 minutes of public comment tonight.
no.
Thank you.
So I had a,
Yeah, one of the things that has happened locally is that they have adjourned the meeting in the middle of the meeting and resumed the meeting and interrupted public comment in that way.
how are they doing that are they calling a special meeting? I mean, I would
They're-
imagine they're calling a special meeting and giving 18 hours notice?
No. Let's consider that,
Yeah,
and
I'm
maybe
not
we'll come back to that. Let me ask, you talked a little bit about polling members. Can you talk about the difference between polling members and a walking quorum, and when they kind of cross the bridge between that? When it's acceptable and when
So
it's not?
polling is literally that, just asking, okay, we're going to vote on approving the superintendent's contract. Are you a yes or no? And that's it. It's not, why are you a yes or why are you a no? And it's one-on-one as opposed to a quorum discussing, although I suppose you could do that as a quorum, but really the cases talk about like one-on-one, like doing sort of a individual poll, one board member going, or maybe the board president saying, how are you going to vote, how are you going to vote? But, 4 members walking together talking about they're going to vote on the superintendent's contract looks very much like a meeting to me, and I would think that that would probably not pass the smell test.
Okay. Let's give the other folks a chance here to talk a little bit about FOIA. There's legislation pending in Lansing right now to make some changes in FOIA. That I know of, none of the changes affect municipal governments, school boards. It's all focused on state government, legislative and gubernatorial. Is that right, or are there changes there that we should know about locally?
Unfortunately, I'm not knowledgeable about the specifics, but I think you're right that it's mostly state agencies and it could be affected. I don't know of any local impact.
I don't know the specific legislation. I know that there has been discussion for some time about particular aspects of Michigan law. As I mentioned in the materials, Michigan is one of only 2 states where the governor is not subject to the Freedom of Information Act. And she has suggested that she is in favor of that change, but it has not taken place. As far as the other specific details, I'm not familiar
Okay.
with the current
Okay.
proposal.
Ralph, I think this is probably a good question for you, maybe for Gary as well. Can you talk a bit about what frank communications means in terms of FOIA and whether a public body can withhold documents from a FOIA request based on that frank communication exemption? Microphone.
The frank communications exemption, and I didn't really discuss exemptions, but in the materials there is a discussion that there is a presumption that information should be public, is public, and that there has to be a justification for it not being released. Among the reasons information may not be released is if it is subject to one of the exemptions under the law, which I've described broadly. One of them is the frank communications exemption. And what that deals with, and I think it's been discussed somewhat in national news as executive privilege, it's the idea that executives are entitled to honest, frank, direct opinions that perhaps might not be shared with the public, in that if you release those frank opinions, you might discourage the executive from getting the best advice. What was the last part of your question about? That's what it is. Was there something else?
I'm sorry, let me look. Whether they can withhold documents using that as an exemption.
Yes, it is an exemption if there are, it would be a common thing though, in something that's been discussed, is that even if there is a partial exemption, then the part that isn't subject to the exemption still would have to be released. So I believe the most famous case along with the frank exemption was dealing with investigations, I believe at Eastern Michigan University, where there had been some misconduct and there were some frank discussions of what should be done with the people who are alleged to have done things. There were also, it was also mixed with a lot of other things that were not advice, and that would be what I would look at in those instances is what is the mix of communication versus just information, factual information, and whether there is some justification. I think that is one of the exemptions that does have a weighing aspect. A lot of them do not, but some of them do have an aspect where the public interest might outweigh the benefits of withholding the information.
Okay. You talked about FOIA-ing documents that have already been prepared. So does that mean that handwritten notes taken by public officials during public meetings are not subject to FOIA?
It depends on what happens with those notes. So if they're just notes that someone's scribbling and then they take them home with them, I would probably argue that those are not FOIAble. Those are notes that public official, they're not an official record of the public body. But if they're notes that are maybe on a document and then the document, is collected and maintained by the public body, then I would say that those are FOIAble.
Okay.
I think the key is whether they're used by the government.
Okay. I want to go back to what you were saying earlier about email, because you said something that personally I found surprising. We know that I would say everybody locally, our city council members, our school board members, they all have official email addresses. And the emails that they exchange on those email addresses, that's all FOIA-able material, right?
Subject to the FOIA
Appropriate
exceptions.
descriptions
Yeah.
and exceptions. But personal emails that public officials are using in which they're discussing public business might also be FOIA-able?
That's how I've advised my clients. And it's in part to scare them into not using their personal devices.
That's the Hillary Clinton example, isn't it?
No, I would say that they clearly are subject to FOIA if they are being used for government business. The issue is it's very hard to show what they've discussed but once that demonstration is made, and some people do something as casual as responding to a group of other government officials with their personal email, and then in that case, it's pretty easy to demonstrate that they have.
So they might
used
be
it.
compelled to share that, in other words?
Yes, yeah.
Okay.
No, it
Yeah.
certainly would be subject. It's just a matter of making the initial demonstration that they have used it.
Okay.
Might be a difficulty, but in some cases it's not.
Interesting. Someone who's serving on a public body is, whether it's a city council or a school board or canvassers or whoever it is, they're likely to be in a good position to know if a body is meeting in violation of the Open Meetings Act. And I'm not talking about declaring a closed session, but if they're meeting at, John's Barbecue to talk about, city business, the public official is likely to be aware of that. How does someone who is a public official object to that effectively? And do they have recourse in the same way to claim a violation, or do they jeopardize themselves because they're part of that body?
So that was my case that I was talking about, where we had two members of the same public body suing for violating the Open Meetings Act. So you can bring a lawsuit. They didn't name the public body, they just named individuals, which, they ran into some issues because that's how they did it. They couldn't get an injunction, for example. They couldn't get their attorney's fees, even though the four were found to have violated the Open Meetings Act by exchanging these emails. And then because there's a 6-month statute of limitations, this behavior had been going on for a couple of years, but they waited too long. And I don't think they waited too long. I think they just took them that long to figure out what was happening. And so by the time they, brought the case, the bulk of those behaviors were outside of that 6-month window. So, but to answer your question, they can certainly bring a lawsuit. I would say I've had clients, individual members of government bodies call me as the attorney for the entity, saying, I think this is what's happening. What do I do? Can we have you come out and talk to people? I mean, generally I find that it's happening out of ignorance as opposed to some sort of maliciousness. If it's malicious, then, that's a different sort of conversation, but usually it's happening out of ignorance. They just don't understand. And so it's an ongoing conversation that I have every time there's an election and we get new people on the board or new people on council, that we have these conversations over and over again to get them to understand that they can't, be doing this. But that's typically how those issues are resolved, is just having me or, somebody who is knowledgeable on the Open Meetings Act come and talk to them, and usually it stops. Now, if it's malicious, then I would say, you're going to be looking at potentially filing a lawsuit.
Okay. So when members of the public are allowed to come into a public meeting, it seems clear that their physical presence is allowed. Are they able to record the meeting? Are they able to bring in a camera? Are they able to use an audio device? Is there anything that restricts them from recording a public meeting in any way?
I don't believe so.
And so it's possible that a recording like that could also be used as evidence of what does or does not occur in
Sure.
the public
I
meeting.
mean, and that's assuming the public body itself is not videoing or recording the meeting itself, which in these times most public bodies
But even
do.
if the public body is recording its own meeting, it still would be okay for a member of the public to do their separate recording. They might have a different perspective, say, than the
Right.
official recording
Yes.
would have. Okay. What about attorney-client privilege? How does that apply to FOIA? What's available and what? Big smiles from the attorneys.
No, it's actually a good exemption to bring up. Yeah, I'm used to, I have a voice that carries, but I know you're recording, so I should be more careful. It's actually a good exemption to bring up because it's demonstrate a point about exemption. Almost all of them are not mandatory. That means that the public body is allowed to deny requests on that basis, but it is not a requirement. I cited two in the materials I provided where it is mandatory, and that's the Student Rights Information Act and the Medical Information Act, where it is illegal to release that information. It's very seldom illegal. It's a decision that's made. And I give an example. It's a strong exemption if it is applied, but on the other hand, if a school board has a legal opinion where it says what they're doing is great, they'll usually be very happy to release attorney-client information. So again, that just demonstrates the point that it is, like most FOIA exemptions, is not a mandatory exemption.
I'll just add, as somebody who advises school boards, I will say we never release attorney-client material, even if it's positive. Yeah, we just, the privilege exists for a reason, and, you know, we don't advise clients to waive it. Now, occasionally it does get waived because there's a more pressing PR reason, for example, but as a matter of course, we don't release privileged material unless they're compelled, and I've never had a client compelled to do that. Usually the privilege is upheld. So.
Can you FOIA detailed attorney bills? Are those subject to FOIA?
They are.
Okay.
We redact, though, if there's material in the description of the bill that would give away the like what we were doing in terms of if it's so detailed, it would disclose the nature of the legal advice that was being provided. But typically, our bills, we've been doing it long enough, we are very general in how we describe things, so they don't need to be redacted for the most part. But with school districts, you know, sometimes you have to redact a student's name.
Like if it was a student discipline case you
Right,
were
yeah.
consulting on?
Yeah.
Can you FOIA a list of the FOIAs that have been submitted to? Christine, you want to talk about that?
Yeah, we do that all the time, usually to get one up on another reporter, you know. No. But I remember Ellen Ha, who used to work for the city, when I started doing that, she's like, "That's not fair, Christine. I'm not going to fulfill those." So I had to go after her. Yeah, she didn't think so. But yeah, no, it's pretty common, and you learn a lot, like what attorneys are FOIAing, because there's so many people other than citizens and journalists FOIAing, and it's really informative.
How specific do you have to be?
I think you just request a FOIA log. You know?
Just all this FOIA submitted to this body during this period of time?
Correct. And then if you want that FOIA that they received, you could separately just give me what Joe Smith FOIA, paid for. And a lot of times, well, the state sometimes will not charge you if they've already released the data, the information. So people are different, or entities are different about it.
So they've charged person one, so they're not going to charge person
Correct.
two who asked for
Yeah.
the same information.
Yeah.
Okay,
So
good
that's a
strategy.
good, and one thing I was thinking that I wanted to mention strategy-wise, a lot of times I'll anticipate their arguments and put, why, this is not an exemption here. You know, this specifically, you've already, like in that Section 8 argument, you could say, hey, I know you already list this stuff on your website, so let's deal with that. That's not an argument because you've already, you know, publicly available. So I think if you're strategy-wise, you can cut the time in terms of the time you go back and appeal and back and forth. So that might be something to think
It
about.
sounds like you do a fair amount of negotiating when you're before you're filing a FOIA with somebody.
Yeah, I will generally, try to talk to the public official before I file a FOIA, because I don't just cold call file a FOIA, because obviously you can, but I don't find it as effective, and I want to try to get the information actually without FOIA, and because it's going to delay me and cost me money. So, and if I'm specific with them, like this is what I'm looking for, I know it's going to, I'm sympathetic. I know you're a poor clerical person, like some of the folks I have to deal with. That they're getting a ton of FOIAs. What can I do to make this more specific? This is what I need. Type conversation is helpful, I think. Yeah, especially with those folks who aren't the public official. You're there. You need to talk to them and tell them you're not trying to make them do more work. You're just trying to get this information.
Yeah. You wanted to add something?
Oh, yeah. Perhaps the first thing I disagreed with other panelists about. The idea, one of my tips for success was going to be exactly ask for things that have already been given, whether it's from a news article, whether often it can be something that is bragged about by the public agency in a press release or announcement. But I recently assisted a University of Michigan constitutional law clinic, and they asked for WXYZ's FOIA information. They had been running a series about police misconduct and officers who were not punished after a series of incidents, and it allowed them to get in the middle of the process without wasting time. I would strongly disagree with any government official who suggested that that was an improper request.
I have a question for Christine. Have you ever been buried by a FOIA request? I mean, somebody who just responds with boxes and boxes and boxes of information because they want to appear to be cooperative, but not really?
Yeah. That's a strategy too. Yeah, to give just a voluminous amount of information, and I don't complain about that. I'll spend time on it. So that's the better of the options, I guess, than totally being shut down. Yeah.
Another Open Meetings Act question. If a public body announces meeting times at the last minute and they're consistently slow to post those meeting notices, they're just always sliding it in, at the 11th hour, as it were, is that a violation of the Open Meetings Act?
It depends on whether it's a regular meeting or a special meeting. Regular meetings have to be decided at the organizational meeting. So that's the notice is at the first organizational meeting. They set the schedule for regular meetings. For special meetings, it's only 18 hours. So they can post 18 hours in advance and have the special meeting within 18 hours, and that's not a violation.
Okay. I want to go back to, again, this is an Open Meetings Act question. We talked about closed meetings. What about just the informal meetings that are happening that are not posted meetings? They're people getting together and talking about city or school board business, not making any announcement about it, and you become aware of it. What's your recourse to challenge that?
Well, so that's not a thing. You can't just have informal meetings like that. That would be a meeting under the Open Meetings Act. So if there's no notice provided before a meeting such as that, that's something, one of those penalties that I talked about, where you could refer them to the Attorney General, or you could bring a lawsuit yourself.
Okay. You want to have any closing comments, the three of you?
Yeah,
Go ahead.
I did want to address one thing, because didn't really get into, I wanted to speak informally, but I did want to make a couple of points about the law, and in particular about next steps if you are denied. I emphasize some of the ways that you can avoid getting in that position, in the fact that you should look at who appeals are going to. Christine has talked about having success with appeals, but sometimes appeals can be quite successful, depending on whether as she mentioned, the body or person is different and has different interests than the person who decided it. It might be a person who's relatively low level and handles 90% of the requests successfully, or at least in the sense of not going to court or some further action being taken. But if the next person up is an elected school board member or something along those lines, they might be concerned about the public. They might be concerned about money if they lose a legal case. They might be concerned about the story being in the paper while the other person is not. Those things can motivate you to act differently. And that is the one thing that I did want to discuss. I didn't put it in the materials, and I should have, is that there are penalties for failure to respond appropriately to Freedom of Information Act, and they're far more in the favor of the requester than the Open Meetings Act penalties are. In, well, just for example, even if you win an Open Meetings Act case, it's discretionary as to awarding lawyers' fees, and if you win a FOIA, if you prevail in a FOIA case, it's mandatory that you do, so that gives you a greater possibility of having an attorney step forward. And again, the attorney's fees can be quite significant, and that can also be a factor in motivating the public body to settle the case and to respond to you if they are in the position of avoiding substantial costs.
I did want to say too, if you get to the point where you want to file suit, you could go and search and read past suits, of people who have filed Freedom of Information Act lawsuits. I know it happens a lot with attorneys who are representing people maybe who are suing police departments. That's how most common ones I see, but it could be a template for someone who wants to pursue that, or even open meetings. I think you could probably find they're maybe not as common as the FOIA lawsuits, but you could do that research in Wayne County. You just go to the basement of Coleman A. Young, and they have public terminals, and so you're able to, as a member of the public, go search those cases. You can't pull the PDFs up online. You can see the cases online search, but if you want to actually read them, you'd have to go to the basement. But you, as a member of the public, have access to that. So,
Last thoughts?
I don't have anything else to add, but thank you for having me.
Okay. Okay, we're going to wrap up, and first and foremost, can we have some applause for these really provocative speakers? It's great. I learned a lot, and I came in thinking I knew a lot, so I thank you very much. We also want to say thank you again to the Grosse Pointe War Memorial for providing the space for this evening's event, and especially to Leah Chelaby for all her work in coordinating all the facets of this. I also want to make sure that you know that Don Drozd and Maureen Krasner, who's been sitting quietly over here all evening, did the hard work of inviting the panelists, putting the panel together, and everything that goes on behind the scenes, along with Sarah Wirtz from Detroit. So thank you, ladies, for all of your hard work. Let me remind you that this evening's event has been videotaped, and it will be available within a few days on the websites for both the League of Women Voters of Grosse Pointe and the League of Women Voters Detroit. So check there for the link, and if you think it would be valuable to share, please share widely. The more people who see this, the more who learn how to, take advantage of these tools that are made available for us. At least on the Grosse Pointe League site, you'll also find links to documents that will help you file FOIAs and educate you further about the Open Meetings Act. Thank you again. Have a safe trip home.